Thank you for joining us for panel 5. We are at day 2 of the Nuremberg Forum, and it is a great pleasure to have you all with us here today. Panel 5 will focus on expert presentations looking at and discussing two various international systems, the United Nations system and the Rome Statute system. The panel looks at their interaction, complementing roles, and reflect on their synergies in enforcing the legal framework, describing the nature, method, and characteristics of the framework that is being implemented. The objective of the panel remains the same, discussing and dissecting the legal framework envisaged in 1950 and subsequently developed into the common fight against impunity. But we will look at the issue from the structural perspective. We have an excellent panel set up today, chaired by Prosecutor Richterova. I will do the introduction of the chair, and then I will give the floor to Prosecutor Richterova to introduce the other panelists as well as the topics for today's discussion. It is our great honor to welcome you all, and thank you for your time for joining us today. Dr. Anna Richterova has over 30 years of experience as a prosecutor. In the years 1999 to 2008, she worked as a trial attorney and later as senior trial attorney in the Office of the Prosecutor of the International Criminal Tribunal for the former Yugoslavia. In October 2008, she took up the position of Deputy National Member for the Czech Republic at Eurojust in The Hague in the Netherlands, dealing with international legal cooperation with respect to a vast majority of cross-border and organized crime cases. Since February 2016, she has served as a prosecutor at the International Department of the Prosecutor General's Office of the Czech Republic. It is a great pleasure to hand the floor to you, dear prosecutor, and thank you very much for chairing this session.
Good morning, good afternoon, good evening, and thank the Nuremberg Academy for inviting me. It's both a great honor and pleasure to be able to attend this year's Nuremberg Forum and to moderate the panel discussion with three highly distinguished guests with impressive career as are Judge Christoph Flüg, Professor Charles Jalloch, and Professor James Stromset. Joanna already mentioned the aim of this panel. On the outset, I would just like to mention something which happened to me this week. Just coincidentally, I met several of my former ICTY colleagues this week, and we recalled our beginnings with the international justice at the ICTY, and most of us joined ICTY in 1999. And I believe that nobody really knew that the establishment of that ad hoc tribunal would play such an important role in the development of the international humanitarian law and criminal law. The ICTY will remain a tribunal of first time for many things. It was unique. It was a unique institution and a pioneer in international legal proceedings. It has inspired the creation of other international or hybrid criminal courts and various investigative mechanisms. And most importantly, it contributed to the establishment of the ICC. We all agreed in our meeting that there was one important factor during our days that we had in common and that may have contributed to the success of the work of the ICTY, and it was total dedication to what we did, dedication and enthusiasm of us lawyers and investigators to help victims of terrible and often unimaginable crimes and to bring the major perpetrators to court, to justice. It brings me to my first question. I would like to invite the first expert, Judge Flieger, to share with us some of his experiences. Judge Flieger has had an impressive career. He was State Secretary for the Justice System of the Land Berlin from 2001 until 2007. From 2008 and 2017, he was a judge of the ICTY. Unfortunately, I missed Judge Flieger because it was the year when I left. And from 2012 until 2019, he further served as judge of the International Residual Mechanism for Criminal Tribunal. I would like to ask Judge Flieger, what has been the most significant and most challenging difference between establishing the ad hoc tribunals in the 1990s and the ICC in achieving long-lasting peace and thus ending impunity? Judge Flieger, it's your floor.
Thank you very much, Anna, and welcome to everybody. I'm very pleased to be able to address you and to share some of my experiences and impressions with all of you. When the Security Council of the United Nations in May 1993 established the International Criminal Tribunal for the former Yugoslavia, the ICTY, it was determined to put an end to violations of international humanitarian law in order to contribute to the restoration and maintenance of peace. However, the establishment of the ICTY had, and now I quote, the sole purpose of prosecuting persons responsible for serious violations of international humanitarian law committed in the territory of the former Yugoslavia, end of quote. The use of the words sole purpose clearly indicates that all other expectations were beyond the responsibility of the ICTY. But on the basis of the judgments and the established facts therein, all other players should try to achieve what the people in the area need for a peaceful and successful life, i.e., first and foremost, the politicians and diplomats, the media and the religious groups, the churches, teachers and historians, and the civil society as a whole. I have severe doubts whether they have fulfilled their obligations properly. On the contrary, the situation in the region is worrying and absolutely not satisfactory. I come back to that later. The ICTY, however, has completely fulfilled its mandate. 161 persons, that means 160 men and 1 woman, have been prosecuted. No one is still on the run. 91 of them have been found guilty and sentenced, and 18 have been acquitted. The trials of the others ended in different ways. That means that the ICTY as an ad hoc tribunal has successfully put an end to impunity of the most responsible persons for war crimes in the respective region. This was, however, only possible because of very specific circumstances. The international forces like UNPROFOR and the NATO troops, UN Blue Helmets, were present in the region and could assist in arresting suspects, secure investigating teams during exhumations and seizure of documentary evidence. In addition, there was political pressure by the European Union on the regional governments who wanted and still want to be admitted into the European Union. The question put to me is whether the International Criminal Court, the ICC, would have been able to achieve this goal as well. My answer is, unfortunately, no. The ICC never had the means to prosecute and try such a big number of relevant persons with respect to only one situation as it is called in the language of the ICC. When I started as a judge at the ICTY in November 2008, we had more than 30 permanent and ad litem judges to deal with all the cases. The ICC, in contrast, has only 18 judges with a limited tenure, which makes it very difficult to maintain experience and the necessary background knowledge. And the ICC has to deal with so many totally different situations around the world, so that in most cases, just one or two suspects are prosecuted. What would happen if the obstacles for paving the way to justice for the conflict in Syria would be overcome? Would the ICC be able to fully investigate the situation in Syria, to prosecute impartially the most responsible persons for war and other serious crimes on all sides of the war? That would go far beyond the capacities of the ICC with respect to the prosecution, the judges, and the other elements of the court. And the support by the law enforcement bodies is missing when it comes to investigations by the prosecutor of the ICC. Hence, with respect to Syria, the best way would be to establish an ad hoc tribunal like the ICTY or the Tribunal for Rwanda, the ICTR. In addition to the ad hoc tribunals and the ICC, there have been some supranational courts in Africa, Middle and South America, who have also successfully dealt with horrible crimes and sentenced leaders found responsible for them. Despite all problems and flaws the ICC has shown in the past years, some homemade, some created by the international community, including the Assembly of State Parties, I still believe in the idea of international criminal law and its institutions. There's nothing better to deal with the most heinous crimes in the world. We all should do our best to improve the current system, and by that to persuade the big powers to join the family of those who believe in law. To put it in the words of Benjamin Ferencz, make law, not war. This indeed would mean long-lasting peace, as this was formulated in the introductory question put to me. However, even this is not certain in the former Yugoslavia. Nationalism is growing again. Some of the current leaders are not interested in peace, but still have the dream for a greater Serbia or other such entities. Perpetrators who have finally been sentenced for genocide or other horrible crimes were treated as heroes, and streets and student dormitories were named after them. How can reconciliation be achieved after a successful ethnic segregation? The last High Representative of the UN for Bosnia and Herzegovina, the Austrian diplomat Valentin Inzko, addressed the UN Security Council in April of this year with these alarming remarks. And I quote, BIH, that means Bosnia and Herzegovina, remains de facto a frozen conflict with unfinished peace, where political leaders continue to pursue war crime goals, generate divisive narratives and nationalistic political agendas, and speak about dissolution of the state. The multi-ethnic and diverse society that existed prior to the conflict has all but disappeared. While it is becoming more difficult to defend the preservation of multi-ethnic spaces and resist the creation of mono-ethnic ones. Hate speech, the glorification of war criminals, and revisionism or outright genocide denial, despite the verdicts of the international judicial bodies, remain very common in the political discourse. End of quote of Valentin Inzko. This is a dangerous situation which has to be observed and addressed by the international community, especially by the European Union. A coherent strategy in this respect is missing. although the European Council had its last meeting in Slovenia dealing with the Western Balkans, but nothing came out of that. Therefore, I call upon the politicians of the European Union and also of Germany to develop a strategy which assists in maintaining long-lasting peace in the former Yugoslavia. Thank you very much.
Thank you for your observations. It's a really pity what's happening on the territory of former Yugoslavia, specifically in Bosnia and Herzegovina. The success of the ICTY was very important, or has been very important, and it had a great impact on the development of the international criminal law, international humanitarian law. Unfortunately, it hasn't had the impact on the ground, on people living in Bosnia and Herzegovina, even in Serbia. The animosity is still there, and it's hard to say whether any possible negotiations run by European Union or others could help the situation unless the politicians in these countries will be willing to change their direction of behavior and their politics. I would like to turn now to Professor Jaloch. The role of the International Law Commission in the establishment of Nuremberg Principles has already been mentioned many times. Since 1950s, the ILC has worked on various projects with different level of success. One of the last projects was or has been the preparation of the draft articles on the prevention and punishment of crimes against humanity. And that should form the basis for the UN General Assembly to negotiate a convention on crimes against humanity. So I would like to now turn to Professor Jaloch with several questions, or at least a couple of questions. Professor Jaloch is Professor of Law at Florida International University in Miami. He's founding editor of the African Journal of Legal Studies and the African Journal of International Criminal Justice, and founder of the Center for International Law and Policy in Africa. But most importantly, he is a member of the United Nations International Law Commission, and he was elected as a chairperson of drafting committee for the 70th session and as a rapporteur for the 71st session. So he is the person who could answer several questions in connection with these draft articles, who can answer the question, why would the Convention on Crimes Against Humanity address a gap or gaps in the current system, and what advancement would this bring to fighting impunity? The floor is yours, Charles.
Thank you so much, Prosecutor Richterova. Thanks to the organizers for inviting me to participate in what has truly been an excellent Nuremberg Forum. We all, of course, regret that we couldn't get together in person, but of course, for completely understandable reasons. I'm, of course, very honored to be on the panel with very distinguished colleagues, of course, Judge Floga and Professor Stromset. And it's a delight to engage in this conversation at this particular moment and to have been asked to speak to these two questions concerning the work of the International Law Commission on the issue of crimes against humanity. Let me just state up front, before I delve into attempting to answer the question, that I'm assuming, based on the discussion yesterday, that the majority of the colleagues in the audience are familiar with the International Law Commission's project, at least in broad outlines, which basically began in 2014 and concluded in 2019, where the Commission engaged in the effort of preparing a set of draft articles that were always explicitly intended to form the basis for the UN General Assembly to negotiate a convention on the prevention and punishment of crimes against humanity. The set of draft articles, 15 in total, and an annex were forwarded to the General Assembly in the ILC report in 2019, with a recommendation in paragraph 42 of that report that the General Assembly either itself elaborate a convention on the prevention and punishment of crimes against humanity, or convoke an international conference of plenipotentiaries that would examine the draft articles and, based on the draft articles, negotiate a convention. It's interesting that in 2019 and 2020, and just this past week, the General Assembly, the Sixth Committee of the General Assembly to be more precise, had debated the text of the ILC draft articles. And by my count, in the debate last week, at least 100 states spoke to the topic, an overwhelmingly large majority of which are very representative from all the different regions, have supported the ILC recommendation. Most have expressed the hope that consensus can now be found by the Sixth Committee to agree on a path forward, especially the possibility of establishing an ad hoc committee with a clear roadmap and defined timelines that hopefully will provide a path forward for states to engage with the text on a substantive and technical level. Of course, we'll have to wait for December to see what the decision of the General Assembly is on this particular item. And I think I cannot stress enough the significance of this moment, given the discussion we are having here, especially centered around the Nuremberg Principles and, of course, the work of the Nuremberg Academy. So turning very quickly to the first question which Anna has asked me, there are, of course, many reasons why the draft articles could help to fill a gap in the current international criminal law system. And I will just make about 4 main points, given the time limitations that we have. I will note, of course, that the conversation yesterday already covered aspects of the draft articles. So let me start with a broad observation to set the stage very briefly. And that point is to note, as a famous Egyptian jurist, the late jurist, Professor Serif Bassiouni, has noted, international criminal law can be thought of as having a two-part system, a system of direct enforcement of international law and a system of indirect enforcement of international criminal law. The system of direct enforcement really relies on the prosecutions of international crimes by international courts. And of course, we just had a very nice and interesting and important discussion concerning, for example, the Yugoslav Tribunal, the ICTY. But we also had the Special Court for Sierra Leone, the ECCC, and of course the ICTR, and ultimately ending up with the ultimate permanent body, the International Criminal Court itself. On the other side of the ledger, so to speak, is the indirect prosecutions of international crimes through national courts. Now, this two-level system has basically developed over time, and we know today that the promise of justice at the national level, the indirect enforcement system, remains a bit under challenge. And the reason for that is, of course, tied to political will, issues of capacity, and of course, very importantly for our purposes, the gaps in the criminalization of international crimes within national legal systems. So that brings me to the first and important point, which I really think is the principal justification by the ILC for undertaking this project, which is essentially to fill a historical gap in the law of international crimes. The point cannot be underestimated in the sense that even if you go to the debate in the Sixth Committee just this week, you'll notice a very important point made there by a number of states, including Germany, which stressed the need to fill the historical gap in the law of international crimes. Why is this substantively important? Well, despite the efforts of states and despite the efforts of the International Law Commission, which, as Anna pointed out, has been engaged in helping develop the system of international criminal law, going back to the Nuremberg Principles, we do not have at the international level a draft code of the international crimes that will be applicable in national legal systems. So instead, at best at the international level, we have what can be described as an eclectic patchwork of multilateral treaties that really reflect the decentralized and ad hoc nature of the development of international criminal law. This, of course, is true when it comes to international crimes. So, for example, when you think about genocide, war crimes and crimes against humanity, we have an unevenness in the legal framework that is quite pronounced. So if we start with genocide as an example, the objective of preventing and punishing the crime of genocide was famously included in the 1948 Genocide Convention, effectively as a result of the deep commitment of the UN General Assembly, in particular its Sixth Committee, spurred on by the hard work of Polish-Jewish lawyer Raphael Lemkin, who is credited with coining the term genocide. And we know that in Article 1 of the Genocide Convention, states defined genocide as a crime under international law, irrespective of whether committed in peacetime or wartime. And of course, in Articles 2 and 3, defined this as punishable crimes under international law, and he had a number of other provisions addressing other matters, including requiring states to take action at the national level to give effect to the content of the convention. That's a significant development that we had in 1948 in relation to the specific crime of genocide. Let's talk about war crimes, the other so-called core international crime. Well, when it comes to war crimes, everyone I think in the audience will be familiar with the four famous Geneva Conventions that were adopted in 1949, and of course that include the so-called grave breaches of the laws and customs of war, in other words, war crimes, in a number of the provisions, including Articles 50, 51, 130, and so on. And then, of course, we had the additional protocols of 1977. The difficulty, as you would then see, is that we had a good system for genocide and crimes and war crimes, but not for crimes against humanity. So that historical gap, when you compare crimes against humanity to these other two core crimes, today remains very glaring. And the effort of the International Law Commission really picks up on its commitment to helping states to develop a regime that will reflect very well Nuremberg Principles 6.3, which essentially is a recognition of crimes against humanity as a crime under international law. Of course, one could respond and say, well, of course, we have Articles 7 of the Rome Statute of the International Criminal Court, which specifies crimes against humanity as a prohibited crime. That's true. The problem is the Rome Statute does not provide an express obligation on states to incorporate crimes against humanity into national laws. It is implicit. And of course, a number of states have gone on to codify the prohibition in national laws. Now, there's an interesting study from 2014 that showed that crimes against humanity are committed throughout the world, but only about half of the states, about 40% of which were states parties to the Rome statutes, had included crimes against humanity in their national laws. So the point I'm trying to make is that this is a takeaway here, is that by adopting a Crimes Against Humanity Convention, the goal would be to assist states to remedy this gap by bringing international crime, agreed in the same way as we have for genocide and war crimes, into the national legal orders of states that choose to become parties to that convention. I'll just make a couple of other quick points. The second significant reason why this is important is, of course, not just to bring crimes against humanity on the same level as the two other core international crimes, but to also provide a basis to address gaps in the current law for the widest possible category crime compared to war crimes and genocide. Obviously, crimes against humanity have a different standard for proof for prosecutors. A related point to note, of course, that relates to the ICC itself is that the principle of complementarity obtains in respect of prosecutions, which means essentially that it is the responsibility of states at the national levels to investigate, and if they find sufficient evidence, then prosecute individuals for Rome Statute crimes, including, of course, crimes against humanity. So the International Criminal Court's regime would only be triggered as a secondary system, not the primary system for the prosecutions of this crime. So having a legal framework that's agreed by states that's consistent with the definition of the Rome Statute will really help to amplify the national prosecutions of international crimes. And at least in respect of the states parties to the Rome Statute, 123 of them would give them the framework that they need to function more effectively in giving effect to that obligation. Now, let me turn to the third reason, which is really, really important. Even for the countries that have national criminal laws prohibiting crimes against humanity, and I'm speaking to you from the United States, where we have fantastic laws on a whole number of issues, including torture and genocide, but the United States does not have a crimes against humanity statute. There's been a discussion of that for many years. Well, the US stands as a very good example of a state that has limitations in terms of its national laws to prosecute, insofar as only individuals who are in the United States who've been accused of other crimes could be pursued, or nationals of the United States in relation to the nationality principle for other crimes other than crimes against humanity. But the gap in the law and the problem we face in the international community does not end there. It goes even further, and this will be my fourth point, because essentially we have the nature of the substantive crimes, the absence of a clear definition, a consistent definition, reflected also in the regime of interstate cooperation, especially thinking here of mutual legal assistance and extradition, where because of the double criminality requirement, if you do not have an arrangement with another state, you are not able to act. So essentially, for this particular component, of course, there's a connection with the ICC itself, where one of the challenges for the court has been the lack of regime of strong cooperation between states and the court. Well, the same is true at the national level, as between two states that may be involved with investigating or prosecuting this crime. So essentially, when you think about the work of the ILC, part of it has been to define crimes against humanity in a consistent and coherent way, much in the same way we've had consistency for war crimes and genocide, but also to address this gap dealing with issues of extradition and mutual legal assistance. Those are the 4 points that I wanted to offer as points for discussion in terms of what this could do if the states were to take it forward to a convention, and I actually take the convention seriously and implement the obligations to fill a huge gap in the development of international criminal law. I'll just turn to the second question that Anna, you asked me, and I'll be very brief here, just being mindful of the time. And really, this is the question as to what the advancements would be if we had the ILC draft articles being taken forward. And I have to say, it's been a huge privilege for me as a member of the commission with an interest in international criminal law, really the highlight to be at the table when these issues have been discussed, given my own experiences working in various tribunals and writing and thinking about crimes against humanity. And what you would take away at a big picture level is that if you think about the ILC draft articles, I tend to think of them as having three fundamental pillars. So three fundamental pillars. The first pillar is the pillar of prevention of crimes against humanity. So the Commission's effort there is to provide concrete obligations where states would undertake not to commit crimes against humanity, to prevent crimes against humanity. That's pillar one. The second pillar is the requirement for states to take national action, so at the national level in their own legal systems, to ensure the investigation and punishment of crimes against humanity, including through criminalization in their national law. So that's the second pillar of the crimes against humanity draft articles. The third pillar is the establishment of mechanisms that I alluded to already for interstate cooperation and mutual legal assistance. This is where effectively the Commission proposed texts that one could describe, and I've described in the Commission, as a mini mutual legal assistance treaty and a mini extradition treaty within the components of the 15 draft articles and the annex that was submitted to the General Assembly. I'll just very quickly just highlight a couple of important things. I mean, there's a lot that could be said about the draft articles. one fundamental point to note is that in the preamble, it's very clear that the Commission found, based on its study and careful study of all the precedents, that crimes against humanity constitute crimes of a jus cogens character, meaning that they are peremptory norms of general international law that effectively rises above, if you will, the element of states, because this is the most important super norms, if you will, in international criminal law. So the underlining by the ILC that the prohibition of crimes against humanity constitutes jus cogens is a significant preambular takeaway that, of course, has been supported by most states in the General Assembly. We have, of course, other provisions in the body of the draft articles that are quite important. Obviously, the definition of the crimes will give that stability. We've seen a lot of inconsistent definitions of crimes against humanity. So we have the definition in Article 7 of the Rome Statute. We have the definition in Article 5 of the ICTY, which basically includes an armed conflict requirement. And then you have the different ICTR Article 3, which basically requires crimes, defines crimes against humanity, requiring a proof of discriminatory intent. All of these inconsistencies could be resolved by having the one definition that the Commission has adopted in Article 2, predicated precisely on Article 7 of the Rome Statute, which basically reflects the views of states, because after all, it was states that sat down at Rome and negotiated that text. So that means that this is what states are willing to take forward in terms of the crimes against humanity, understanding and definition at the international level. So really, really significant development that will give that stability to this crime. There are a number of other provisions that I'll just highlight very quickly. We have the provisions dealing with prevention and punishment. This draft articles 4 and 5. But we also have draft article 1, which basically underlines that crimes against humanity have the same kind of status as genocide in international law, in terms of states making the undertaking that these are crimes under international law. They can be committed in peacetime or wartime, so there's no conflict nexus and so on. And there's an express obligation on states to take the obligations forward and do what they need to do in terms of their national legal systems. There are other components of the articles that are very, very important. So, for example, there's a draft Article 7 that calls for them to establish national jurisdiction. You have an audedere adjudicare obligation, basically predicated on Article 6 of the Convention Against Torture. You have obligations on the part of states to ensure that victims and witnesses are provided for. It's quite fascinating, very important development. You don't see that in the prior conventions, obviously reflecting the modern sensibility to the rights of victims. And Anna pointed out this is really why a lot of people have gotten into the business of international criminal law, because of the concern about victims. And there's an express obligation to provide restitution, compensation, satisfaction, rehabilitation, cessation, and guarantees of non-repetition. Quite significant. And of course, a dispute settlement clause as well. I've run through very quickly, basically what would be vignettes, highlights of the draft articles, just to give you a flavor for some of the substantive text. I will just end with the point, which is an important point to make, especially given my own role as an ILC member and, of course, an academic. You don't want to be presenting an imbalanced view. You want to be objective about some of these issues. And ultimately, is to note that while the Commission's articles have been broadly well received by the academic community, by, of course, states themselves and international organizations, there have been criticisms of them as well. And basically, if I can caricature the arguments, the essence of it is that there are a lot of people who think the Commission could have gone much further, okay, much further than the Commission has proposed in relation to a variety of issues on amnesties, immunities, and so on. But my own view and response to that, and I think the response of the Commission might be to say, look, the Commission has a responsibility to look at what the precedents are in terms of the codification of crimes against humanity, but also in terms of the progressive development of international law. And don't forget, the ILC's documents and recommendations become recommendations to General Assembly, and it will be for states to decide in their negotiations what they would be willing to accept. And I would note historically, when the ILC was asked to produce a draft set of a statute for the ICC, the International Criminal Court, what the ILC proposed changed substantially in some respects, but also substantially remained at Rome in terms of the broad outlines. But of course, that is the proper process. We are independent experts in the Commission. We make proposals to states based on the law, and it will be for states to decide on how to best to address some of those issues. So I'll just leave it there so I don't use up the time of my colleagues, but really, really fascinating. And I think the effort as a takeaway by the Commission is to help remedy this big historical gap in the law of international crimes, whereby crimes against humanity are put on the same level, so important crime as genocide and war crimes. And if you look around the world today, if you look at what's happening in Myanmar, if you look at what's happening in parts of Africa and Latin America, there's clearly a need for a Crimes Against Humanity Convention. Of course, that will be for a decision for states. And it is my hope that the ILC's contribution for the General Assembly and states and the international community will be defined and taken forward by the states themselves for them to actually agree on the content of the obligation. So it's very important that states agree on this, because criminal law would then require that they go back and implement those obligations. So it would be what would be acceptable to states, hopefully at a high level in terms of the prohibition and punishment of crimes against humanity. Thank you very much.
Thank you, Charles. This was really very interesting, and we could spend lots of time discussing on each point you just raised. But unfortunately, we do not have time, and also unfortunately, we do not have the opportunity to meet in Kuala and discuss it. But one day we will definitely be able to do it. But you raised quite interesting point, which occurred to me only later, that although crimes against humanity were with us since the Nuremberg, we do not have any convention we haven't started, or we didn't start at the time when we had a genocide convention, or when we discuss war crimes. Why didn't we discuss crimes against humanity? And it is true, if you take the national law, there are usually provisions on genocide or provisions on war crimes, but the crimes against humanity are missing, or at least many of the key provisions of crimes against humanity. Anyway, yeah, I am aware of the time, and I would like to turn to our last panelist. We have heard a lot about achievements, drawbacks of international justice, and we also see the advantage of national justice. As you know, many countries, mainly European Union's countries, are establishing war crimes units within their prosecution services. I can name France, Germany, or Sweden, who are actively investigating perpetrators coming from Syria, but also investigating other crimes based on the principle of universal jurisdiction. I have probably quite difficult question for our last panelist, Professor Songbek. But as she is a distinguished expert, as shows her biography, she will definitely answer this question. Jane Stromset is a professor of international law at Georgetown University, specializing in post-conflict justice and accountability and international human rights. She served in government as deputy to the ambassador at large for global criminal justice at the United States Department of State from 2013 and 2015. So my question, where do you see lacunas and room for improvements in the common fight against impunity? And what would be your suggestions going forward for strengthening justice and prevention.
Thank you so much, Prosecutor Viktorova. I'm truly honored to be here and grateful to the Nuremberg Academy for convening us, and to you and to my fellow panelists for this very valuable conversation. And a common theme in the remarks of both my panelists is the importance of connections between international criminal law and advancing justice and accountability for atrocity crimes at the national level, and the challenges of building long-term prevention and long-term peace at the national level, an endeavor that, as Judge Fluge so eloquently stated, takes many different actors at the international, regional, and national level to accomplish. And we've also seen, as Professor Jallow so eloquently discussed, the value of a Crimes Against Humanity treaty with the aim of encouraging domestic implementation of international criminal law and better cooperation and prevention and bringing perpetrators to justice. And as Prosecutor Viktorova mentioned, universal jurisdiction prosecutions. And so what I'd like to do is pull all this together by focusing on what I will call a synergistic, catalytic global criminal justice, namely strengthening constructive synergies between international criminal law and advancing justice and prevention on the ground at the national level. And my main message is that better understanding and incentivizing catalytic synergies between international justice and national justice on the ground is going to become increasingly vital to countering impunity for the worst international crimes and strengthening prevention in the years ahead. Now, to be sure, this isn't easy, and sometimes it isn't even possible. As we know all too well, there are many, many situations where the prospects for domestic justice are totally blocked, where powerful actors, domestic actors themselves, are committing atrocities, and where international justice proceedings or universal jurisdiction cases in other countries and continuing gathering of evidence may be the only viable way forward, at least for the time being. Yet, even in the face of stubborn obstacles, international criminal law and justice mechanisms can still, at least to some degree, catalyze and contribute in various ways to creating potential openings, to generating constructive pressure for justice on the ground over time. And I think we have to remember that circumstances can sometimes change and produce unexpected openings, as we're seeing in Sudan today, with all its challenges. You know, when I served in government at the State Department, we were dealing with a very different situation in Sudan than we're seeing now. So I think we have to continue with persistence and determination and patience, pressing on the international level, at the regional level, and building partnerships with change agents at the domestic level to create and catalyze openings at the national level. So what I'd like to do in answering the very important question that the prosecutor put to me is focus on how international criminal justice has the potential to be a vital catalyst for justice and prevention on the ground. And I'm going to first talk about what I mean by catalyzing fair justice on the ground. Secondly, what are the main gaps and areas for improvement that need attention? And third, and relatedly and most significantly, what concrete steps can be taken to strengthen the prospects for catalyzing justice and prevention of atrocity crimes more effectively in national systems over time? So on the first question, why is catalyzing fair justice on the ground so important? And what does fair justice on the ground even mean? And by that, I mean nationally based processes, which can be hybrids of various kinds in the directly affected country, that are professional, transparent, consistent with international standards of due process and basic principles of human rights law. And fair not only in terms of due process, but also in terms of even-handed, in terms of who is actually prosecuted. And why is working to catalyze and encourage fair justice and prevention on the ground so important? It's vital when you think of the larger goals of fighting impunity and prevention of atrocity crimes, of trying to build a stable society around the rule of law. I mean, indeed, international criminal justice is rooted in foundational principles of human rights and human dignity that are essential to a stable rule of law. The idea that nobody is above the law, that everybody, no matter your position, is accountable to the law and to certain fundamental rules of conduct and human rights, and countering the expectation of powerful actors that they're invincible, that they enjoy total impunity, is contrary to building a social and political order where human rights can actually be protected and justice advanced and prevention of horrific atrocities achieved over time. So these are some of the reasons why strengthening justice on the ground is so imperative, and I think we would all agree with the importance of that endeavor. But then comes the hard part. What are the main gaps? What are the main areas for improvement that need more attention? And that's my second question. And let me just highlight briefly 3 main gaps and areas for improvement. And those include, as we can all see in many parts of the world, gaps in accountability, tears in the fabric of justice where major perpetrators, often state actors, continue to enjoy impunity for horrific crimes, as we see Syria, Myanmar, Afghanistan, many other situations come to mind. Next are complementarity gaps in meaningful, sustained capacity building for building justice on the ground. There's a lot of support conceptually for the idea of complementarity, but it takes resources, commitment, time, and the efforts of multiple different actors at different levels, as Judge Fluge so eloquently discussed. And so the conceptual commitment is often not matched by the practical commitment. Third are gaps in education and empowerment. And this goes to a point that Prosecutor Viktorova made about the importance of engaging effectively with communities on the ground. While there's a growing appreciation of the importance of meaningful outreach, I think there's not enough being done to engage with different stakeholders in innovative ways to address their concerns about justice, to deepen awareness of international criminal law principles, and to empower affected communities to advocate for their rights. So those are some of the gaps in accountability, complementarity, and education and empowerment. But what I really want to focus on are what are some of the suggestions going forward, because as they used to say in government, don't bring me problems, bring me solutions. And so what I'd like to do is talk a little bit about some solutions and some approaches that might be helpful in trying to catalyze effective justice on the ground. The first, for accountability gaps, the first sort of approach is to expand accountability options and the reach of international legal frameworks. And I think here what Professor Jallow talked about with the Crimes Against Humanity initiative is an example of taking international principles and trying to expand their reach into domestic systems, enhancing ability to cooperate and join together in prevention. Another, of course, is to encourage countries to join the ICC, to adopt their own statute into domestic law, encourage countries to support hybrid and other justice mechanisms more effectively, more meaningfully, and to enlist regional actors and domestic civil society actors in these efforts. So, these kinds of initiatives are perhaps the hardest politically, and yet probably the most straightforward conceptually, right? Ways to try to advance and expand the reach of international criminal law frameworks into domestic law. Second, and enormously challenging, are catalyzing complementarity capacity building through progressive and innovative partnerships. And I think we have to think much more rigorously and systematically and with greater nuance and differentiation about how to advance complementarity, how to advance incentives for justice on the ground through international criminal courts and frameworks. And I find it helpful to think about a kind of typology of complementarity that might have some different dynamics. So, for example, complementarity can be conceptualized and its potentially catalyzing impact it can be examined in different ways, and these include quite, basically responsive or defensive complementarity, where the ICC can catalyze and incentivize states to take meaningful domestic action to avoid ICC prosecution. There's also positive or proactive complementarity, which involves the ICC or other actors working to actively encourage and potentially even assist domestic efforts to prosecute Rome Statute crimes. There's a variant of that that's sort of cooperative complementarity, where there might be a more explicit division of labor between an international court like the ICC and domestic efforts. And I think of the Central African Republic hybrid as an illustration of this, where there's a hybrid court on the ground that brings national and international actors together. It's making some headway, important headway. And there's a cooperative division of labor between the International Criminal Court and I think the actors working in the CAR Special Court. But I want to stress, we can't expect the International Criminal Court to bear the burden of all of this, right? It is a court. It is a judicial institution. It's not a social welfare agency. And there need to be, as Judge Fluge said, enlisting of the efforts of actors at the international, regional, and domestic level to work on advancing the project of justice on the ground. Another dynamic I'll call parallel complementarity. And this is worth encouraging, even in situations where there's no ICC jurisdiction. There may still be a mobilizing impact of the Rome Statute, of the court as a kind of beacon of the call for accountability that galvanizes civil society advocates and actors around the world to demand justice from their own institutions, to demand justice in whatever ways it can be achieved and advanced in the near term if domestic justice is blocked. I think of examples like Syria, South Sudan. And actually, I was inspired by the thoughtful remarks yesterday of Sarah Kasande from Uganda about the structural obstacles to justice and prevention. And so I think we should think about the idea of a structural complementarity where, in light of the small number of cases that the ICC and other tribunals are able to prosecute, there needs to be more attention to the structural factors that contribute to injustice and atrocity crimes and how to galvanize actors around a larger structural process of trying to advance justice and prevention on the ground. I think the reason I set out this typology is because I think there may be different dynamics at play and different kinds of partnerships that could be more effective in advancing complementarity in different situations. I think in all of these situations, we're going to have to see more creative partnerships built, both on the supply side, on the capacity building side, building prosecutorial and judicial capacity in national systems. And some of the hybrid courts have been able to do that, I think, quite impressively and effectively, at least developing capacities that remain in the country over the longer term. I think we need to see a greater role of regional actors and South-South capacity building, people from a region that may understand more acutely the barriers, the challenges, and can provide leadership within the region. The CAR Special Court is another example where we're seeing some of that. But we also have to have a greater focus on demand-side capacity building, which is a focus on supporting civil society justice advocates and their struggles and their efforts to work for justice and accountability from domestic legal institutions. And that brings me to my third suggestion, which is a greater focus on supporting empowerment and education from the ground up, right? There's a tendency for international criminal justice to sort of focus, and many experts to focus too much on what goes on in The Hague. And of course, what goes on in The Hague is essential, and credible justice pursued by international criminal courts is vital to achieving some measure of justice for victims, some measure of accountability for perpetrators, and indeed to have any prospect of catalyzing some of these impacts I'm talking over time, there has to be the prospect, the threat of credible justice. But we also need to do more and do better to engage meaningfully in outreach with victims, survivors of directly affected communities. And it's vital to take seriously the fact that there are very often contested views, competing views, divergent views of justice, divergent views of what justice should look like. And I think we should not sugarcoat that. I think those of you who worked in the Balkans, are all too familiar with this. But I think of a more forthright engagement with these issues with affected communities could be constructive. And I think of the Special Court for Sierra Leone as an example of this, because their innovative outreach program involved going in town hall meetings across the country, listening to the critiques of the population, many of whom said, why are you prosecuting the big fish and not the perpetrator next door who chopped off my arm? Why are you just focusing, why did you start with the Civilian Defense Force? Why not the RUF? So they raised, I think, very fundamental questions about justice and the justice that the hybrid court was pursuing. And rather than run away from those questions, the court engaged with those and talked them through with the affected population, listened to the affected population, and I think in the process helped galvanize what I think of as a kind of Socratic dialogue about justice and what justice, the struggles of justice, and I think gave the population a greater understanding and a greater appreciation for the work of the court. Related ideas are to do more to make sure that ordinary people understand international criminal law principles and their rights and their options. Another idea is to aim to nurture solidarity across difference. Even when you have communities that are very divided, they may have experienced a common pain. I met with Syrian mothers whose children were incarcerated, in many cases murdered, in Assad regime prison torture chambers. Some of them came from very different communities, and yet they had a common bond in that experience. And they also were looking to be change agents. So I think we need to look at survivors as agents of change and try to help transform pain to power in supporting domestic efforts to galvanize for justice and accountability. Another idea is we need to, I think, look at specific cases as opportunities to educate. So I think of the Lubanga case, and the former prosecutor has talked about how that case and the prosecution for forced recruitment and use of child soldiers in the DRC was able to be a sort of a force for debate and reflection, not only in the DRC, but also triggering debates on child soldier recruitment in Colombia and Sri Lanka and Nepal. And I think we don't have a lot of cases at the international level, but I think they can be a vehicle for engaging with the public more effectively. This is not communications, this is not PR, this is an attempt to really engage on the difficult and challenging and important issues of justice through a kind of public strategy of education. Relatedly, we need to make sure militaries and militias are more fully aware of their obligations to respect international humanitarian law and their awareness of what might meet them, what fate might meet them if they don't abide by the fundamental principles that they are accountable to. And here, I think the crystallization of the criminal law and the Rome Statute, including the elements of crimes, very tangibly codifies relevant law, providing concrete guidance and a foundation for the training of militaries and the teaching of international criminal law in law schools around the country. So I will wrap up with that. I know I've gone on a bit long, but just to sum up, I think the intersections and the synergies between international criminal law and encouraging fair, credible domestic justice, accountability, and prevention have become ever more important. And that even in the face of enormous obstacles, we must keep a clear focus on persistently working to catalyze, to exert constructive pressure, and to create openings over time for building justice on the ground, for advancing synergistic, catalytic global criminal justice. Thank you.
Thank you so much. We heard really encouraging thoughts. We could develop a very interesting discussion. Unfortunately, we have like 10 more minutes. What I would like to say that we should all realize that we cannot burden the ICC as a permanent court with all the problems of the whole world. There is also other responsibility. Therefore, the ICTY, ICTR, the ICC should serve as institution who shows direction how to approach cases on the national level. I think this is quite important. I would like to give you each 2 minutes, Charles, Christoph, just to comment on what Jane just said. Some of your reflections, because this was really excellent what Jane proposed. So I would start with Judge Fricke.
Thank you very much. I indeed was impressed by the overview on what has to be done in the future. This is indeed a long list of duties for everybody in the world. And there are so many areas where we have to dig deep. My problem is always, on one hand, I'm very optimistic when I look back what has been achieved in the last 2-3 decades. This was not expected. Nobody could rely on that really will happen. On the other hand, I'm quite pessimistic because the world has changed in these 2 decades. In the beginning of the 90s of the last century, we had the hope that the world would stay together. We are now divided again into very different areas. So we have to, but again, I would quote Benjamin Ferencz, never give up. So, and this is, that should be the way ahead, working in all these fields. For me, as a judge, the law and the implementation of the law is the most important focus. All other things have to be done as well. And I'm very grateful for Charles that he explained what the Law Commission, the International Law Commission, is doing. That was always my problem, that the material relevant regulations in the ICTY statute was so different from the ICC statute. So to synchronize all these legal backgrounds is very important, and I think you are doing a very great job in that respect. So that was all what I want to say. Let's go ahead and work hard, although I'm retired.
Thank you. Charles, just very brief reflection.
Thank you so much, Anna, and thanks, of course, to Jane and Christoph. I think really fantastic discussion, and I really appreciate looking ahead and how we have to think about the options. And as Christoph says, going back to Ben Perez, never giving up. Because for me, one of the first points that I underline and take away from this is we never give up. We thought that certain progress had been made by the international community. We took certain things for granted, but we see a sliding back. But we have to keep the faith. I think that's what the Nuremberg Principles are about. When you think about the quest for accountability, which Nuremberg itself was an achievement. Remember, there was a first failed effort right after World War I. And it shows with the permanent court that we have today in historical terms, that when you don't give up, you get some results. So that's really my first key promising, if you will, more positive view, because I tend to be an optimistic person by nature. Second point is to underline the need for creative solutions. And I really appreciate Jane's stress on looking at all the tools that we can have, whether it's hybrid, national, international, focusing on positive complementarity, because ultimately, as we all know, as we've seen with the challenges for the ICC, and George Fluger talked about, the ICC and its capacity relative to the ICTY. The ICC is asked to do what the ICTY was supposed to do in multiple situations. So if you think of the ICC, it's an international criminal tribunal for 12, 14 different situation countries, without the judges, without the tools, without the money and the support to do its job. So ultimately, the need for creativity, including looking at all the options, including at the national level. And I want to stress maybe and add a little bit about the regional level, because we see movements in Africa now to have a regional court that will prosecute the crimes. So if you don't get the prosecutions at the national level, African states, when they get this treaty into force, then they could do it at the regional level. Then you get to the international level. So all as a takeaway to stress and my agreement that we need to develop the law, but we also need to keep an open mind and look for creative solutions so that the different situations that we have can be addressed and never giving up. Because I think more than anyone, the international law community has a commitment that we ought to give for this area. And I really am, for me, the International Law Commission remains a vital institution in this area. And I would note as a final point that in the ILC, I have had the honor of proposing a topic on universal jurisdiction, because we see also there are problems with the application of universal jurisdiction. So the Commission is proposing to do a study in this area. There are lots of states that are excited about it. Of course, there are also states that are a bit concerned. The bottom line is the Commission, in my view, should try to help states to develop the law. When we get more laws, as Judge Fluger says, then we basically then focus on how best we implement them. Thank you very much. It's been an honor to be here. And Anna, I had the pleasure of working with Anna on the ICC expert panel. She's always been a fantastic colleague. It's great to see all of you.
Thank you all for your presentations, your interesting your thoughts. It's a pity it's the end. And my last task is to wrap up, which is very difficult task, but I can already see Klaus. But I will use the sentence which has been now repeated several times, and it should become our motto, just never give up. And as Jane Stromset said, we should really look into all possibilities to use all tools, whether international permanent court, ad hoc courts, various mechanisms, national courts, but we have to work, and we have to be enthusiasts and totally devoted what we do. And then there is a future for international justice. So thank you very much once again, and thank you for inviting all of us.
Thank you very much, Anna, and thank you all very much, Jane, Christoph, and Charles, for these very impressive discussions, of which I took a lot with me. Most importantly, that on the one hand, we do have all these various aspects and angles to pursue international justice. On the second note, it's also important that we keep things somehow together. It can't be that the courts diverge completely from each other and use different tools. This is why the ILC, I think, will play in the future also a pivotal role of keeping things together, that even if we have regional, domestic, international proceedings on all levels, they at least follow the same principles and the same standards. We see it in the European Union, how difficult it was to establish a tiny little thing which is called the European Public Prosecutor's Office, and the discussion is still ongoing on that. And this is just a very, very small, tiny element in pursuing international justice on a European level. And that shows that this is going to be a while. And yes, you need courage to work in international criminal law. And if you do not have a glass half full, but rather a glass half empty mentality, then it's going to be very depressive. All of you have shown a very strong glass 3/4 full attitude to these problems, and I thank you very, very much for that. It was really a pleasure to listen to all of you, and I hope that we will meet again very soon. I know, Charles, we have the pleasure of coming together on Tuesday already next week. I'm looking forward to that event, which is also an important discussion, which we will hold. Different details for that, if you want to register, you can find on our website of the Academy and the website of the Center for International Law and Policy in Africa, CILPA. Good, thank you very much. We have now a short break for all of you to either relax or grab a quick coffee, or to use our interactive platform, which we have. So you might be able to meet and to talk to someone, although it's not in the foyer of the Nuremberg Palace of Justice. It's in the foyer of the virtual Nuremberg Forum this year. And all of you, thanks again. And we come all back at 2:30 sharp to continue with the next panel. Thank you very much, and all the best for you.